Hi, this week we are continuing our discussion of therapeutic jurisprudence by having a look at some examples of how different systems of specialised courts or problem-solving courts have been created to follow this idea of changing courts so that they are more actively engaged in solving the problems in and around criminality. So, whereas the role of traditional court sort of ends with sentencing, where people are sentenced, or sometimes they're found they're not guilty, but when they are found guilty, they're sentenced and then they're handed over to the penological system. The problem-solving courts see themselves as having a much more ongoing role and much more embedded in the community. Now, this is quite a change in approach for Anglo-Australian American common law courts. It is not such a big difference for European courts, because European courts, judges have always had a role outside the courtroom. So you'll have a judge involved in a police investigation, and judges have a much more diverse role under the European most of the European court systems. But fairly early on in the English court system, which we have inherited, we kind of shut the judges away and said that in order to be objective, we needed to have them cut off from the rest of society and just judging. And that, of course, has some problems, particularly where there is no qualification required to be a judge beyond the legal qualification. So there's been regular calls for judicial training to help judges transition to the role of being a judge. Usually they're barristers who get elevated up to being a judge. And then they're usually very experienced in court, but they're not necessarily very experienced in anything around the issues that they'll be dealing with in court. And it's not unusual for someone who might be a commercial litigator to become a judge and then be judging criminal cases where they have to discuss issues around poverty and health and mental health that they have absolutely no experience of. So anyway, the idea of the specialist courts has been not only to expand the role of the courts, but also to expand the interface between the courts and other systems, and to keep the judge in charge, but to keep the judge connected to these other systems. So a judge is going to talk to other people and listen to them, and not just say, if it's not in the law books, it doesn't count. So in your notes for this week, there's a reference to Berman and Feinblatt's 5 elements of problem-solving courts, specialised courts. This is a pretty good summary, I think, of those. So one is case outcomes. So they focus on providing tangible outcomes and tangible change in the lives of the people, victims, offenders, and everyone else are involved. Not just like a symbolic, you've been punished and this has been the judgment of society. They're actually looking at, well, what's actually going to change as a result. 2, they focus on systemic changes to try and re-engineer our approaches to justice. So they're innovation focused for our purposes. 3, that judicial monitoring is important, that having a judge involved and a judge continuing to be involved in the lives of the offenders is important. So the judge is not some remote distant person who just passes judgment and then you're gone. The judge is then going to be involved in later stages as well, and particularly in monitoring and reviewing someone's progress. That there's collaboration between governments, non-profits, community groups, and the 5th is that there are non-traditional roles. Specialised courts engage judges in unfamiliar roles, asking them to convene community meetings or broken relationships with social service providers. So I think that's a good little summary, and that's on the page 4 of your notes for this week. And I think it helps us see that the problem-solving courts are doing more than just solving problems. They're not doing more than just coming to a resolution in the way a traditional court will. They are actively involved in looking at the social problems that underlie an issue and trying to solve those problems. So their scope is still limited to, the particular accused person who is appearing in those courts. And while their engagement with the community, I think, is a useful way of them to be connected to broader social change, one thing problem-solving courts can't really do is make broader recommendations to government and say, look, we're seeing a lot of people from this area facing real problems that come out of poverty. Perhaps the government should be looking at intervening more in this area and making changes to improve people's lives. The problem-solving courts are still focused predominantly on the issues that are before them and the criminal activity that brings those people before them. But that being said, they have a lot more latitude to think about the things that impact on those individuals and to look at what help they need beyond just, what the traditional courts can provide, which is really not much in terms of help. It's just, threat and pain of punishment. Okay, so let's just I'll just run through a few of the different problem-solving courts that are around. Queensland actually has quite a lot of them, and they're mentioned in your notes. And Queensland's actually been through quite a period of change in terms of recognising problem-solving courts, and that's interesting. And I'm not quite sure why that's the case. Possibly the rolling effect of reforms after the Fitzgerald inquiry, which I know is 40 years ago now, maybe going on for 50 years, 40 years. But I think that was an opportunity to start looking at things in a different way, and that got a lot of balls rolling, I think. So I'm not an authority on that. That's just my intuition as to why Queensland seems to be more of an innovator than other states in terms of the problem-solving courts. All right, let's just talk about some of these and what they do. The workshop this week will look at the domestic violence court and the drug court in a bit more depth and have a look at a closer examination at what they do. So first of all, the drug courts. Obviously, these are used when someone is convicted of drug offences, but they're also used where someone is convicted of other offences and drug offences are connected to those offences. So, for instance, someone who is an addict, who is engaging in crime, who's doing robberies or fraud or whatever to get the money to fuel, to feed that addiction, or someone who whose use of drugs is leading to bad behaviour, someone who uses ice and gets involved in fights because ice pushes behaviour towards sort of aggression and violence. So there's usually a cluster of different offences, and this, I guess, is also one reason why it's important that the therapeutic jurisprudence model is based inside the legal system. So a lot of other models of that we looked at in restorative justice are about referring people out and saying we'll refer them out to another group, and that group will have a have a mediation or a council or whatever and come up with a solution. But because people, for instance, in the drug courts are going to have a lot of other things hanging over their heads, not just the drug offence, then it is really important that those things, that we are very careful that everything stays within that legal system and that person's legal rights are protected, and they're not encouraged to, for instance, confess to things they shouldn't confess to. All right. One of the things that's interesting in terms of the success, are they successful? Yes, they're very, very successful. I mean, I think in some places they've seen like 30% increase in success. In New South Wales, they've claimed that drug courts have saved them $1.8 million a year, which is pretty good, particularly for a court process that is slower, more intensive, and more difficult than a conventional court. The conventional courts are very much geared to being, the factory model. Bring them in, bring them in, convict them, sentence them, shoot them out. All these problem-solving courts are going to require more time, more attention, more training, more specialised personnel. And even then, New South Wales said, yeah, we still saved almost $2 million a year doing these. So I think that's positive, and that's one reason why I think, drug courts are a great example to hold up. One thing they've found that I think is particularly interesting is that deterrence has a stronger effect with drug courts, because you have continuing contact with the judge and with the process while you get yourself sorted out. Now, deterrence in criminology has generally been a failure. It's generally been a situation where we've said threat of punishment really isn't a deterrent. For various reasons, and I'd refer you back to your criminological theory for that. But here's a situation where there does seem to be deterrence, where in terms of recidivism, the fact that you're going to have to go back and see the judge and see the court person, the drug court personnel, does seem to be an incentive for people to get their act together, to say, look, if I relapse, then I'm going to have to face up to these people, and I don't want to do that. Also, the offenders feel there's a stronger sense of legitimacy and fairness in the process. And when we're just looking at drug offences, drug offence, the criminalisation of drug use is problematic in itself. Way too much there for us to discuss in a short workshop as part of a greater course. But I'm sure you guys know that the use of criminal justice system to treat drug use has always been problematic, and we've had things like prohibition that have been extremely problematic. So the actual effect of on behaviour change, of using criminal justice to change people's behaviour, is going to be low, because there's a perception that it's a really unfair process. However, with the drug courts, they found that there is a much higher perception of fairness amongst offenders. And I suspect if they are successful in showing that what they're doing is out of a sense of care rather than a sense of judgment and punishment, then that is going to seem much fairer than someone saying you're a bad person because you use drugs and we're going to throw the book at you. But saying we're part of a profession that wants to help you, and we're recognising that the drugs are doing these things that are damaging your life, they're creating problems for you, then that, I think, is a much more likely to be perceived as fair than the traditional hellfire approach to punishment of drugs as a moral crime. All right, let's cover a couple of other ones. Mental health courts have also been used in a lot of places. The success rates of mental health courts, unfortunately, are not as high. In some ways, your intuition sort of, or at least my intuition, common sense intuition would be, well, wouldn't these be more successful because of the problems that people with mental health issues have in conventional courts? But those who have reviewed them have shown a very small amount of improvement, have said that usually there are bigger, more complex social factors that the mentally ill offender is part of that are more likely to be determining the criminality. So if you're someone who has long-term mental illness, who's not being treated, who doesn't have resources, who can't hold down a job, you're likely to be influenced more by poverty as a causal factor in criminality than the mental health itself. That being said, the promise of the mental health courts is to provide a fairer interface for people who have difficulty with the conventional courts because of their mental health illnesses. So success doesn't necessarily require a reduction in crime rates, although we would all like that, and the governments that fund these bodies would certainly like to be able to say it has like a 30% reduction in the drug courts. Incredible. That's you couldn't really hope for something like that. So everyone would have liked to be able to say, yeah, mental health courts, really good, gets people back in under the care of the system, stops criminality, whatever. But their primary objective is really to provide a more humane experience for people suffering from mental illness. And from that approach, they seem to be quite successful. All right. What else have we got to discuss? Family violence courts. We've talked about those a bit in the past. Again, rates of success are moderate. Unfortunately, domestic violence is such a big issue that it kind of needs its own category to frame it, which is, of course, what we're trying to do by setting up family violence courts. But it's hard for anything to make much of an impact on rates of family violence. There has been a small amount of reduction in recidivism, which is good. We'll take that. We'll take even a small reduction. But what's interesting is, in terms of success, is that there's been a much higher rate of satisfaction from those involved in the process. So that's something to ponder, I think. The fact that it's okay, it's reasonably good at reducing recidivism and incidents of domestic violence or family violence, but it seems to be really good at having people satisfied with the process. And that's something to think about. Because on the one hand, making people feel better but not actually influencing the crime rate significantly, is that just lulling people into a safe sense of security, a false sense of security? I mean, we know from the general studies on domestic violence, there's always a honeymoon period. There's usually a honeymoon period where the offender is remorseful and sorry for what they've done. They promise they'll never do it again. There's a danger that maybe this is the same thing, that going to the family violence court is part of that honeymoon cycle. I know better, I won't do it again. Everyone walks out of it happier, including the victim, but it's not going to necessarily reduce the rate. I don't want to criticise it too much because there is some reduction in recidivism, so let's not knock it down completely, but also let's be wary of rates of victim satisfaction in something complex like domestic violence, where that satisfaction might be based on something that's usually, I mean, I think it's usually sincere. The apologies are usually sincere, but there's something that drives the offenders that seems to be outside their control. Indigenous sentencing courts are another problem-solving court used around the place. Queensland has the Murray Court that seems to be quite successful. Again, it's in a fairly similar position, I think, to the mental health courts, in that the rates of recidivism, there's not a strong amount of evidence. There is some reduction in recidivism, but it's not a big reduction. But then again, is the primary purpose of the court to prevent future crime, or is it to provide a more humane, comprehensible process for the offender? And it seems to be on that level, like the mental health courts, they seem to be quite successful. That people are who are in the court are more able to understand what's going on. They're more able to understand the consequences, and it's located within an appropriate cultural setting. I was talking not so long ago to the former Attorney General of Victoria, and his early experience was as a lawyer in outback Australia, and he dealt with a lot of Indigenous accused, with a lot of Indigenous clients, but also a lot of Indigenous witnesses and so on. And he said one of his early experiences that he found particularly heartbreaking was he brought an old First Nations man in as a witness. He'd seen a crime take place, and they went into court, and the guy just jumped straight into the dock, because his whole experience of the criminal justice system was, I don't know what's going on, but I have to get in the dock because I'm being accused of something. And they had to coax this poor guy out and convince him to sit where in the stand and take his oath and give his evidence, and that he wasn't in trouble because his whole experience of anything to do with the law was just him being in trouble for something. So I think, we would like these systems to have better outcomes in terms of stats, in terms of criminality, but even just on the humanitarian basis of providing a process that is better for people who are disadvantaged under the conventional system, I think we have a success there. The last one I want to talk about is one I haven't known a lot about until I read what Massa had written, which I think is quite intriguing, is the idea of re-entry courts. It's the idea of, when we're used to the process of the police do their part, they hand someone over to the court does their part, they hand it over to the penal system does, and there's no follow-up. The idea of re-entry courts is that they actually get involved when someone is released from prison, they're released from imprisonment, and they actually assist someone in getting re-established in society. So these are relatively new. There is not a lot of data yet, but the initial data is looking really good. 45% reduction in recidivism within 18 months compared to other prisoners who went through conventional parole system. So they've not been around long enough for us to have really long-term data, but then again, people don't tend to offend over a long period most of the time anyway. So we can be cautiously positive about these, and this is a completely different idea for justice. This idea that the courts, once someone has served a term in prison, get involved again and actually get involved in trying to get someone re-established and serve their needs, is a very, very radical, perhaps, but it's definitely an innovative idea. And again, another anecdote from a friend who's worked with prisoners that I found particularly, it struck a chord with me, was a guy who'd been long-term in prison who was being released, who told her that he was really worried that he might get hit by a car because he'd spent 10 years in an environment where he wasn't around traffic. And he could barely remember what it was like to walk on the streets where cars were. And that, he's just not used to that. And there's a real danger that he might walk out onto the street and, not check if there's a car coming. And to me, it was just such a simple thing that's part of our everyday life that we don't really think about in terms of incarceration, let alone all the other things about having your life so closely controlled and monitored, and then being put in a situation with, like, oh, you're outside now, live your best life, do what you want, you're free now. And of course there are some services, and they're often charity services that seek to get people reintegrated into society. But I think it's a really interesting idea to actually have the courts involved and have a formal part of that process. So that's very much a watch this space idea. It's a new idea, it's a really innovative one, and it's going to be worth seeing what happens as time goes on.